Welcome to Uxbridge FM's legal show. Today we're chatting about the very important subject of wills. And we're really pleased to welcome local solicitor Alannah Macdonald. And you're from the Sethi Partnership based in Eastcote.
That's correct.
Well, thanks so much for popping into Uxbridge FM today. Just give us a quick overview of the Sethi Partnership and what your role is there.
So I'm a solicitor within the private client department. That means that I deal with wills, lasting powers of attorney, anything to do with the probate, declarations of trust, all of that sort of information. We then, as a firm, offer all your usual high street areas of practice, so criminal, litigation, conveyancing, both residential and commercial. We also do family law, so we're quite wide-ranging in our approach. We also deal with immigration. So, as I said, it's for the everyday client to ensure that we obviously can do pretty much everything that the local individual would need.
Right, so first of all, what is a will and why do I need a will?
So a will is a legal document by which a person, often known as the testator or the testatrix, expresses their wishes as to how they want to distribute their assets after they die. This is referred to as estate in terms of legal terminology. And it includes your property, your money, all your possessions. And it just makes it easier for your family and friends to sort everything out when you do die. Without a will, the whole process can be a lot more time-consuming and stressful. It also will help reduce any inheritance tax that might be due on your estate and the money that you leave behind. So it's especially important to draw up a will and to get that legal advice. It's also really important if you have children or other family members that actually are dependent on you, whether that be financially or whether they're minors. And it's just to also ensure that it covers any people that aren't technically family members, so an unmarried couple or sort of children of a partner. So it's to set things in place and make sure that what you want to happen actually happens after your death.
So who should have a will? Everybody or a certain age, or how does that work?
So you have to be at the age of 18. So everyone over the age of 18 who owns a property or has a child or children or any other assets like a business, for example, they should draw up a will in order to safeguard and dictate how they wish to distribute their assets. It's also important to have a will regardless of your marital status. So whether you're married or in a civil partnership, or whether you're an unmarried couple or you're a single person, a widow or a divorcee even, it's important to draw up a will to reflect your wishes and make sure everything's covered. It's also particularly important nowadays on a second marriage to ensure that both sides of the family are equally respected.
Yeah, and are there different types of wills that exist?
So the main two types are usually a single will and a mirror will. A single will is, as it says, it's for a single person or someone that wants to do something completely different to their spouse or partner. And a mirror will is generally for a couple. It can be married or an unmarried couple. It really doesn't matter. It just means that they're distributing their estate in a similar way to each other.
Okay. And who can I put in my will? Pets and things and animals or people?
Yeah, you can put anything in your will. We have obviously a lot of clients that ask us for a lot of different things. So usually wills are used to cover minor children, so those under the age of 18, such as appointing guardians or deciding how they should inherit your estate at what particular age. 18 is always considered a little bit too young to inherit quite a large sum of money. It's also to protect those who are unable to handle large sums of money. So if they've got a disability or they're seen as a vulnerable person, or even if they have personal issues, so they're not usually good with saving. And I'm not just on about, obviously, students that like to spend money. I'm on about those that maybe have personal issues of that nature. It can also be helped to ring-fence assets for the generations to come. So it's to make sure that things are all tied up in a nice little bow as such. It then protects everything. As I said before, it can also be used for different sides of the family. So whether it's a second marriage or a second relationship, and you've each got children or different families, It's to make sure that both families are then obviously adequately provided for. As you said, it can provide for pets. It can outline funeral wishes, because it's something that not many people discuss. It can also protect your estate from the possibility of people contesting your will. So it's to make sure that we outline everything as possible and go into as much detail as you need to and you want to in a legal document, so it's a bit more binding. It can also leave certain gifts or money to charity if you want to help reduce your estate or just sort of give a token of goodwill. And it can also ensure a partner or someone you live with still has a place to live. It's not always a guarantee once you pass away.
And can I pop down Smith's and just get the will pack and write the will myself, or is it advisable that I go and see a solicitor to get a will?
So in a simple answer, yes, you can. People can obviously search inheritance tax information online or go through other sources. However, it will not necessarily help you draw up a will that's legally binding. We always say that make sure that you get adequate advice, whether it's just sort of a one-off consultation with the solicitor, or obviously we do that for free. Other companies may charge for that. But it allows you to sort of get all the information. If you then decide that you want to have a go at it yourself, then by all means. However, we do encourage clients to spend that little bit of money to make sure that whatever they write down will have the legally binding effect that they want it to do so, protect them in the way that they want it to do so, and obviously make the use of any tax legislation available at the date of their death.
And then, is a will fully legally binding? I mean, you can contest wills, can't you? But obviously there's sometimes loopholes and things.
Yep, so there's never a fully guaranteed way of protecting your will from it being contested. However, those contesting your will must have sufficient grounds in order to contest the will in the first place. So this usually falls into one or two categories. It's that it's invalid in the first place, or that your will didn't make sufficient or any provisions for that person. So it's usually a child that's been completely isolated or excluded from the will, we say. Secondly, there's only certain individuals that can contest your will. And they usually have to have a beneficial interest or a potential beneficial interest in that person's estate. So if they believe they have a valid claim, the burden's on them to prove why they can have a claim. Those contesting a will usually are the spouse, surviving children, any cohabitees or other dependents such as adult children that were financially dependent on the deceased. We usually say to people, if you are going to exclude somebody from a will, or obviously not make provisions for someone in any way, shape or form, or unequal provisions, which some people do, that you write up a statement and draw up all the reasons as to why you're making those decisions. That will then be used in a court of law should your will be contested as to the reasons why you wrote your will in a particular way.
So the big question, what will happen if I don't have a will? You must have lots of horror stories about people who didn't have wills and their money went to the wrong place or the wrong people.
Yeah, of course. When you don't have a will and you die, you're known to have died something called intestate. That means that you've died without a will, or in some cases without a valid will. So where it's not been signed properly or dated or anything like that. It would then be the law, as you said, that decides who gets what. Now, obviously everyone assumes that husband and wife, they automatically get everything. That's not actually the case. So what happens or what's dictated by the law might not be in line with your wishes. Your spouse won't necessarily get everything. They'll get a particular amount, and then anything over that amount is split between them and any children you may have. Obviously, that's not applicable if you've got no children. It will just go to your spouse. If in the event of a whole family tragedy where a spouse and children obviously all die together, then it could start going to parents and brothers and sisters and nieces and nephews, and the list goes on and on. So it's about making sure that whatever you want to happen with your assets in your estate, it obviously goes to the right people in the proportions you want to. Everyone likes to think we've all got happy families, but the reality is some people don't speak to their siblings, they don't speak to their parents, they don't speak to their children. So it's about making sure that everything that you want to happen after your death actually happens.
Yeah. And then, of course, there's tax to pay, isn't there, as well? Inheritance tax. When does that all come about? How does that work?
Sadly, yes. Inheritance tax becomes due on the estate after a person has died. Now, it's the tax that's levied on the estate, as I said, the money, the property, the possessions that are acquired by gift or inheritance. There is no inheritance tax due if your estate is under the £325,000 threshold. So this is known as the nil rate ban, and it's available to everyone. So there's no restrictions or criteria. You just need to be a person and own assets. There's no inheritance tax between spouses either. So you're completely exempt whether you pass £1 or £1 million. However, you can then use your deceased spouse's tax rate after the second death. So, for example, mum and dad are passing their estate down to children. You can then use double the nil rate ban, which totals £650,000 currently. In 2017, the government introduced the residential nil rate ban, and this was also transferable between spouses. The idea of the residential nil rate ban was to potentially increase an individual's inheritance tax-free estate up to £500,000 as an individual or up to £1 million as a couple. Now, there were a few loopholes and criteria you had to meet. And obviously, as I said, it was a potential, so not everyone would get it. It started when it was introduced at £100,000. And the idea was it scaled up every year by £25,000, every tax year that is, so that by April 2020, which is only a matter of months away, the value of the residential nil rate ban would be worth up to £175,000 as an individual or £350,000 as a couple. That's on top of the existing the existing nil rate ban. So you'll have the £650,000 as a couple, plus the £350,000, which comes to a grand total of £1 million by next April. Currently it's £950,000, so not far off. And then as an individual, you'll get the £325,000 and the £175,000, which obviously then comes up to £475,000 currently. But as I said, by next April, that scales up by another £25,000, which is £500,000. So once you're under those figures, then there's no tax to pay.
You've got to be a bit of an accountant, haven't you, as well, to work out all the figures? Yes,
it does require a few sort of calculations in the background to make sure that everyone sort of uses as much as they possibly can.
Yeah. So if I leave everything to a charity, how does that work? Does that get taxed still?
So if you leave something to charity in your will, then it won't count towards the total taxable value of your estate. It's called a charitable legacy. Charitable gifts that are left in your will are outside of your estate before inheritance tax, which enables you to reduce the tax paid on your estate. You could even wipe out it entirely if you leave over your nil rate ban to a charity. You can also cut the inheritance tax rate, which is usually 40% above those threshold figures that I just gave, from 40% to 36% once you leave over 10% of your net estate to charity.
Okay. And what about tax-efficient ways of signing over your house to your children? Is there a sort of time period that's best to do that in?
A lot of people tried to do this a number of years ago to avoid inheritance tax and particularly nowadays care home fees. It's really not a good idea because the government believed that if this is the reason why it has been done, then it could be seen as a deprivation of assets, and basically they'll still count it for any inheritance tax purposes. Furthermore, you could end up paying your own children the going market rate to live in your own property. So we always say to people, if you're going to do it, speak to a solicitor, discuss your options, discuss what's obviously available to you. There are ways nowadays to set up provisions to protect and ring fence some of the assets for, say, care home fees or inheritance tax purposes without possibly giving up the right to your own home.
Mm. Now, I read in the paper the weekend that there's 2/3 of the adult population in the UK that don't have wills, which seems pretty amazing to me. I mean, for those that do have wills, though, how often should you update it? Obviously, if your circumstances change, that makes sense. But
of course.
Yeah.
So we usually advise clients every 3 to 5 years. The reason being is, obviously, as you said, there could be major changes in the personal circumstances, such as marriage, divorce, or children and even grandchildren. Could even be that you've moved home or acquired a new property or more property. It could also even be setting up a business. We also say 3 to 5 years due to governmental changes. So as and when tax legislation changes, if it's going to severely affect your particular circumstances, if you've got quite a large estate, then it could be worth you going to see a solicitor or a tax advisor to make sure that your wills are set up in the most tax efficient way, so that you hopefully minimise your exposure to inheritance tax.
Are there some funny things that happen with civil partnerships and people living together without being married?
Yeah,
Loopholes there.
You get a lot of people that just assume that obviously living together or being married, that it will automatically go to a spouse. The answer is yes and no. If you get married or you get remarried or you get entered into a civil partnership, then your will becomes automatically revoked. So you might have had one as a single person or as a divorcee. As soon as you enter into that new stage in your relationship, your will automatically be revoked. Now, you can put a clause in it in advance to protect that. That's another issue. However, divorce, on the other hand, doesn't automatically revoke your will. So it will revoke anything mentioned to your ex-partner or your ex-spouse or civil partner, I should say, from benefiting under your will. But most divorce solicitors will actually advise you to update your will during divorce proceedings to protect any assets like that.
Yeah. Fantastic. That's some very, very good advice there. Now, you've been in law for over 4 years, so plenty of experience, and the Sethi Partnership. Tell us about the Sethi Partnership based in Eastcote. How many solicitors, and what's their sort of main core business?
So we've got a fairly substantial team there. As I said, there's sort of 20 of us in total. We deal with all high street practices. So we've got the family department, we've got private client, as I said, which I belong to. We've got residential, we've got immigration, criminal, we've got litigation. So we deal with a range of areas of law for everyone to come and see us. We've been established in the area for over 20 years now. We obviously have our various specialists. We are approachable. We like to treat our clients as an individual. So although you come through the door, it's not the typical thing that, yes, you're paying a solicitor lots of money to obviously deal with your issues or anything that you may have. But we're professional and dynamic. So we make sure that everything we do, you can trust the advice you're given. It's obviously tailored to you. You're not just on a conveyor belt. And we spend the time with you to make sure that the advice you're given makes you feel like an actual individual. So a lot of solicitors get a bad rap for just fees and money and things like that and sort of clock watching. We pride ourselves on giving that personal service, that tailored advice, so that clients don't feel rushed. They've got the expertise and the advice that they need, and obviously then they can go away and make the decisions that they need to based on that advice.
Well, thanks so much for popping into Uxbridge FM today. That was fantastic. I've learnt so much today.
Thank you.
And hopefully we'll see you again with more legal advice. Thanks, Alannah.
Thank you. Bye.